Not for stealing, not for fraud, for debt. And it was completely legal. This isn't a hypothetical. Investigations by ProPublica and the ACLU have documented cases exactly like this. Old medical bills turning into warrants after missed court hearings? It happens thousands of times a year. Here's how it works. You go to the ER one night. Food poisoning, nothing dramatic. You get treated, you go home, and a bill shows up a few weeks later. $340. You mean to pay it. But life happens. You move apartments. The bill slips through the cracks. You forget about it. But the bill doesn't forget about you. A collections company buys that debt for pennies on the dollar. They send letters to your old address. Then they do something most people don't even know is possible. They sue you. Not a threatening letter, an actual lawsuit filed in an actual courthouse with your name on it. A hearing gets scheduled. The notice gets mailed, again to that old address. You never see it. You never show up. And the judge issues a bench warrant for your arrest. 6 months later, you're driving to work. Taillights out. Cop pulls you over, runs your name. Suddenly, you're in handcuffs on the side of the road. They didn't arrest you for owing money. They arrested you for missing a hearing you didn't know you had. Debtor's prison was abolished in 1833. And yet, this keeps happening across the United States. By the end of this video, you'll know exactly how this is legal and how to check if it's already happening to you. Plus, the one step that stops the whole thing cold. Quick note, this is legal education, not legal advice. Laws vary by state, so check your local rules or talk to a legal aid attorney. Many are free. So here's the thing most people get wrong. Debt collectors can't arrest you. They're not cops. They don't have badges. They have spreadsheets and phone scripts, but they don't need to arrest you. They figured out how to get the court to do it for them. Think of it like a chess move. The collector doesn't go after the king directly. They move a pawn into position, a civil lawsuit, and let the court do the rest. The collector files a case saying you owe money. If you don't respond, the judge gives them a default judgment. That's basically a court order saying, yes, this person owes the debt. Now the collector has something they didn't have before, the authority of a judge. But here's where it gets dark. Once they have that judgment, they can subpoena you. Think of a subpoena like a hall pass in reverse. Instead of giving you permission to go somewhere, it demands you show up. The court orders you to appear and answer questions about your finances. What's in your bank account? Where you work? What you own. It's called a debtor's examination. And if you don't show up, you're not ignoring a debt collector anymore. You're ignoring a judge. That's contempt of court. And contempt of court comes with a bench warrant. The kind that pops up when a cop runs your plates at a traffic stop. See the trick? At no point did anyone arrest you for owing money. They arrested you for not showing up to court. But you didn't show up because you didn't know about it. And you didn't know about it because the notice went to an address you haven't lived at in 2 years. The system isn't broken. It's working exactly the way debt collectors designed it to work. And before I show you how to protect yourself, you need to understand just how common this is. Because this isn't some rare legal glitch. Studies in Illinois, Missouri, and Minnesota tracked these warrants. Thousands of them, every year. And researchers found a pattern that should make your stomach turn. These warrants are overwhelmingly concentrated in low-income zip codes. The people most likely to move frequently. Most likely to have outdated addresses on file. Most likely to never see the court notice. The collector's entire strategy depends on you not knowing the game is being played. Their legal team has a term for people who don't respond to lawsuits. They call them default judgments. Easy wins. Revenue. So here's the question that matters. How do you know if this is already happening to you? Think about every medical bill, credit card, old phone contract, or gym membership you've ever let slide. Any one of those could have been sold to a collections agency, and any one of those agencies could have filed a lawsuit you never heard about. Here's what you do. Go to your county courthouse website, or just search your name on your state's court records database. Most states have a free online portal. You're looking for civil cases with your name as the defendant. If you find one, look for the words default judgment. That means a case was decided without you. If there's a judgment against you, check if there's a subpoena attached. If there's a subpoena you missed, that's the danger zone. That's where the warrant lives. Now, here's the part that changes everything. If you find a judgment, you're not helpless. Not even close. You can file what's called a motion to vacate the judgment. Sounds fancy. It's not. It basically says, Judge, I never got proper notice of this case, so I never had a chance to defend myself. Courts take this seriously. The whole system is built on the idea that you actually know you're being sued. If you can show the notice went to a wrong address, or that the process server's records are sketchy, and trust me, a lot of them are, the judge can throw the whole thing out. The judgment, the subpoena, the warrant, gone. It's like hitting undo on a nightmare you didn't even know you were in. But wait, it gets better. In many states, debt collectors have to follow strict rules when they sue you. They have to serve you properly. They have to file within the statute of limitations. Think of the statute of limitations like an expiration date on old debt. In most states, that's 3 to 6 years. If they sue you after the clock runs out, that case is dead on arrival. It's like trying to use a coupon from 2018. Expired. Doesn't matter how much you owed. And here's a twist that makes debt collectors sweat. There's a federal law called the Fair Debt Collection Practices Act. It sets rules for how collectors can contact you, what they can say, and what they have to prove. If a collector violates it, and they do this more often than you'd think, you can countersue them. The person trying to squeeze money out of you could end up writing you a check. Their lawyer's letter basically said, pay up or else. Your lawyer's letter says, you broke the law getting here, and now you owe me. Completely legal, completely satisfying. So let's go back to that traffic stop. You're sitting there in handcuffs because of a $340 ER bill from 3 years ago. But now you know something the version of you in that scenario didn't. You know the warrant wasn't for the debt. It was for a missed hearing. You know you can check your county court records right now, today. And you can find out if there's a judgment waiting. You know you can file a motion to vacate. You know the statute of limitations might already protect you. And you know that if the collector broke the rules, they owe you money. That person on the side of the road didn't lose because the law was against them. They lost because nobody told them the game had already started. Now you know where to look before a traffic stop finds it for you. Go check your court records. Not tomorrow, tonight. Because if there's a warrant out there with your name on it, the traffic stop that finds it won't wait for you to be ready. Here's the real question. Should courts be allowed to issue arrest warrants over debt hearings when the person may never have received the notice? Drop your answer below, because this is a policy that affects millions of people, and the debate isn't even close to settled. If you enjoyed the video, make sure to like and subscribe, and make sure to leave a comment on what topic you'd like to see next. Thanks for watching.